We'll have Reverend Mark Marston. Would you step up, sir? If I get everybody be a little quiet for a minute, I've asked the good Reverend to tell us a little bit about himself and his congregation before he offers prayer.
Thank you very much. Yes, I'm Reverend Mark Marston, Senior Minister at the First United Methodist Church, which is often known as the Pumpkin Church down the street because that's how people remember us. We're one of the oldest congregations here in the state and part of the National Historic Registry. And it's wonderful to be in this hallowed place. So thank you very much for inviting me.
Thank you, Reverend. Stand for prayer, please.
Let us pray. Our Lord in heaven, creator of all things seen and unseen, we give you great thanks for this beautiful day, the sunshine, this time together. And our Lord, we give you great thanks for the much needed moisture that we've had. Bless these women and men who are here to face issues, not just for themselves, but for all who live in Wyoming. They carry the voices of those who are voiceless, the young and the aged, the working and the retired, the rich and the poor, the learned and the learning, the blessed and the struggling. Fill them with your Holy Spirit, that they might be kind, gentle, patient, and wise. These things we pray through Jesus Christ. Amen and amen.
Thank you. Senator French, would you lead us in the pledge?
States of America, and to the republic for which it stands, one nation, indivisible, with liberty and justice for all.
Thank you. Thank you, Reverend. Oh, yeah, we just jumped right into it. I was ready to go to work Monday morning. We'd like to have roll call.
Roll call for
Accountability.
Monday, March 22nd, Legislative Day number 23. Anderson, Baldwin, Beitman, Boner.
Excuse.
Here.
He's right here.
He's out there.
Bouchard, Case, Cooper, Driscoll, Ellis, French, Murphy, Baru, Hicks, Hutchings, James, Kinski, Kolb, Cost, Landon, McEwen, Nethercott, Pappas, Perkins, Rothfuss, Salazar, Schuler, Scott, Steinmetz, Wasserberger,
Here.
and President Dockstader. 30 present.
Reading, correction, approval of journal.
Mr. President, your Journal Committee reports that the Journal of March 19, 2021 has been read and recommends that it be approved. Senator Kolb, Chairman.
Appreciate Reverend Marston for offering prayer. He'll be with us throughout the week. University of Wyoming continue to offer their medical services. We have the phone number up here. Today in Wyoming history. In 1881, the first telephone exchange was established in Wyoming. Doesn't say where, but 1881. In 1996, it said 69, but I'm going with 96, U.S. President George H.W. Bush appoints Dick Cheney as the 17th U.S. Secretary of Defense. Quote of the day, don't let yesterday take up too much of today. Will Rogers. Session status at this point, folks, this is where we're at. Today is the last day for Committee of the Whole in House of Origin. Today is the last day for second reading in House of Origin. This Wednesday is the last day for third reading on bills in House of Origin. For the record, tomorrow is the last day for second reading in House of Origin. We have messages from the House.
From the House of Representatives, March 19, 2021. Mr. President, the following bills passed the House in an amended form. Message number 216, House Bill number 229, Livestock Identification Choice Act, ayes 60. Message number 217, House Bill number 156, 24-hour wine permits, ayes 60. Message number 219, House Bill number 188, Irrigation District Loans, ayes 51, noes 7, excused 2. Message number 220, House Bill number 193, County Attorneys Representation of Special Districts, ayes 41, noes 18, excused 1. Signed, Wendy Harding, House Chief Clerk. Message number 215, March 19, 2021. Mr. President, the following bills passed the House on third reading. House Bill number 120, ayes 53, noes 7. Message number 214, House Bill number 115, Big or Trophy Game Animal Minimum Hunting Age, ayes 57, noes 3. Signed, Wendy Harding, House Chief Clerk. Message number 14, March 19, 2021. Mr. President, the House of Representatives has completed consideration of the budget bill, Senate File 1, dispensing with further reading. Message number 213, conferees appointed, Joint Conference Committee 1. Mr. President, the House appointed House conferees to meet with the like Committee number 1 from the Senate on amendments to Senate File 1. The House conferees are Representative Nicholas, Chairman, Representative Kinner, Representative Larson, Representative Schwartz, Representative Walters. Signed, Wendy Harding, House Chief Clerk.
House bills on first reading. House Bill 156, first reading of the bill.
House Bill 156, Alcoholic Beverage Permits, an act relating to alcoholic beverages, sponsored by Representative Sherwood, passed the House, ayes 60.
House Bill 156 is assigned to Committee number 7, Corporations. House Bill 188, first reading of the bill.
House Bill 188, Irrigation District Loans, an act relating to intergovernmental cooperation, sponsored by Representative Hunt, passed the House, ayes 51, noes 7.
House Bill 188 is assigned to Committee number 5, Agriculture. House Bill 193, first reading of the bill.
House Bill 193, County Attorneys Representation of Special Districts, an act relating to county officers, sponsored by Representative Craigo, passed the House, ayes 41, noes 18, excused 1.
House Bill 193 is assigned to Committee number 1, Judiciary. House Bill 229, first reading of the bill.
House Bill 229, Livestock Identification Choice Act, an act relating to agriculture, livestock, and other animals, sponsored by Representative Neiman, passed the House, ayes 60.
House Bill 229 is assigned to Committee number 5, Agriculture. Reports from standing committees.
March 18, 2021, Mr. President, your Committee number 7, Corporations, Elections, and Political Subdivisions, to whom was referred Senate File 28, Motor Vehicles Security Interest Perfection, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Boner, Case, Driscoll, and Nethercott. Excused, Senator Scott. Senator Driscoll, Chairman. March 19, 2021, Mr. President, your Committee number 1, Judiciary, to whom was referred House Bill 85, engrossed, unlawful dissemination of an intimate image, respectfully reports same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman. March 19, 2021, Mr. President, Committee number 9, Minerals, Business, and Economic Development, to whom was referred Senate File 141, Business Entities Representation in Detainer Cases, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman. March 19, 2021, Mr. President, Committee number 9, Minerals, Business, and Economic Development, to whom was referred House Bill 10, engrossed, COVID-19 Large Business Relief Program, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman. March 19, 2021, Mr. President, Committee number 9, Minerals, Business, and Economic Development, to whom was referred House Bill 69, engrossed, Division of Banking Fees, respectfully reports same back to the Senate with a recommendation that it do pass. Ayes, Senators Anderson, Beitman, Cooper, Rothfuss, and Wasserberger. Senator Anderson, Chairman. March 19, 2021, Mr. President, Committee number 2 Appropriations, to whom was referred House Bill 76 engrossed, Uniform Statewide Payment Processing, respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz. Senator Kinsky, acting chairman. March 19, 2021, Mr. President, Committee number 2 Appropriations, to whom was referred Senate File 121, State Funds, Investments, and Distributions. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Guru, Hicks, Perkins, and Steinmetz. No, Senator Kinsky. Senator Kinsky, acting chairman. March 18, 2021, Mr. President, Committee number 2 Appropriations, to whom was referred House Bill 121 engrossed, state-funded capital construction. Respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes Senators Guru, Hicks, Kinsky, Perkins, and Steinmetz. Senator Perkins, chairman. March 22, 2021, Mr. President, Committee number 10, Labor, Health, and Social Services, to whom is referred House Bill 109 engrossed, Local Health Officers' Education Requirements. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Baldwin, Bouchard, Furphy, Hutchings, and McEwen. Senator Baldwin, chairman. March 22, 2021, Mr. President, Committee number 4, Education, to whom is referred House Bill 120, Hathaway Scholarships Success Curriculum in Middle School. Respectfully report same back to the Senate with a recommendation that it do pass. Ayes Senators Beitman, Rothfuss, Salazar, and Scott. Excuse Senator Ellis. Senator Scott, chairman.
Bills on second reading. Senate File 145, election runoffs. Reading clerk.
Second, Senate File 145, election runoffs.
Senate File 145, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Bills on third reading and final passage. Mr. Majority Floor Leader, do you have a consent list?
Thank you, Mr. President. Yes, we do have a consent list. I would move for adoption of Senate File 78, Real Estate Appraisers Continuing Education, Senate File 118, Federal Emergency COVID-19 Relief Funding, and Senate File 126, Real Estate Subdivisions Easement Requirements.
Having been read 3 separate times, the question is, shall these bills pass? Oh, would anyone like to have that removed from the list? Okay. Having been read 3 separate times, the question is, shall these bills pass the Senate? Senate File 78, Real Estate Appraisers Continuing Education. Senate File 118, Federal Emergency COVID-19 Relief Funding Appropriations. Senate File 126, Real Estate Subdivision Easement Requirements. Chief Clerk, call the roll.
Roll call on the consent list. Anderson. Baldwin. Beitman. Boner.
Aye.
Bouchard. Case. Cooper. Driscoll.
Aye.
Ellis. French. Murphy. Guru. Hicks. Hutchings. James. Kinsky. Cole. Cost. Landon. McEwen. Nethercott. Pappas. Perkins. Rothfuss. Salazar. Schuler. Scott. Steinmetz. Wasserberger.
Aye.
Dockstader. On the consent list, 30 aye. Senate File 78, are there any changes? Closing vote. Closing. Vote closed. Senate File 78, 30 aye. Senate File 118, are there any changes? Closing vote. Closing. Vote closed. Senate File 118, 30 aye. Senate File 126, are there any changes? Closing vote. Closing. Vote closed. Senate File 126, 30 aye.
Having received the affirmative vote of a majority of members elected to the Senate, Senate File 78, Real Estate Appraisers, Continuing Education, Senate File 118, Federal Emergency COVID-19 Relief Funding Appropriations, Senate File 126, Real Estate Subdivisions Easement Requirements have passed the Senate. Continuing with third reading, Senate File 142, third reading of the Senate file.
Senate File 142, Prohibition on Private Funds for Conducting Elections, sponsored by Senator Steinmetz, an act relating to elections.
There is an amendment. Read in the amendment.
Senate File 142, third reading amendment number 1, page 2, line 3, after.
Senator Beitman,
Thank you, Mr. President. I move third reading amendment number 1 to Senate File 142 and ask for your favorable consideration. Ladies and gentlemen of the Senate, I had a good talk with the Secretary of State and his assistant on Friday morning. We sat down and worked out this amendment to alleviate their concerns as well as the concerns I heard on committee of the whole from the good tall senator from Natrona County. So that's the impetus behind this amendment. It's on page 2, line 3, after election insert. This subsection shall not apply to the Secretary of State when accepting or expending private funds for the explicit purpose of election training or education, nor shall this subsection apply to meals or food provided or donated in support of election training or education or provided on election day to poll workers and other staff. So hopefully that hits all the points of contention on this bill, and I'll stand for any questions. Thank you, Mr. President.
questions for the sponsor? Questions for the sponsor? Ready for the question? Whoops. Senator
No, on
Perkins.
the amendment.
Yeah, we're on the amendment. On the amendment. Question on the amendment? All those in favor say aye.
Aye.
As opposed, nay. The amendment has passed. We are back on the bill. Senate File 142. Let's go Perkins, Kinski in that order. Senator Perkins.
Thank you. Just a question for the proponents of this bill. In the United States Supreme Court, Citizens United versus the Federal Elections Commission, there was a general prohibition against private corporations and contributing 2 or 4 candidates and a number of things like that. And ultimately, in a close split decision, but nevertheless, the decision by the United States Supreme Court came back and found that ban was an improper, was an infringement on First Amendment rights. And so my question for the opponents of this bill is, ultimately, this is a ban on the state accepting private funds to conduct elections. And ultimately, I'm just wondering, I understand it's not for or against a candidate, but in the past, even before Citizens United, it was private companies could do a number of things to educate the public and other things like that, but couldn't advocate. In this case, this is a ban on the government accepting donations to help conduct the legislation, which isn't even for or against a specific candidate. So I'm just wondering how this passes this, if they've thought about it and how this passes, and maybe the committee members can help, but how this passes the constitutional muster of Citizens United, which is not exactly the same, but is nevertheless there. Thank you, Mr. President.
Before we go to a sponsor, let's continue. We did have Senator Kinski, who is now here, but he's changed his mind. Senator Scott.
Mr. President, on that particular point, and I was the no vote in committee, as I remember, but the Citizens United, Mr. President, was based on free speech concerns. And the holding was designed to protect the constitutional right to free speech. Mr. President, I don't see how that free speech is involved here. What the evil this bill is trying to prevent, that we've seen in some other states, is that large wealthy individuals have made contributions to the states in return for changing the rules under which the elections are conducted a bit. And that's not free speech. So I don't think that the precedent really has anything to do with this. And I don't see a concern Citizens United. Now, I have seen a concern with, that's not happened here. I don't think would happen here, given the integrity with which our officials run our election system. But I don't think that issue that is present in Citizens United is at all present in this bill, Mr. President.
Further discussion before we go back to a sponsor, Senator Landon.
Thank you, Mr. President. Just a quick note or two. Driving home the other night, I thought a lot about this bill, and I guess what I'd like to hear from the proponents is a little bit more about the depth of what this might mean. At a time when we're having to really tighten our belts, Mr. President, a budget that reflects a $400 to $450 million in cuts. It always felt like to me that the months leading up to this session that we were going to have to be open and very welcoming of any opportunity for public-private partnerships. I just wonder if there is ever going to be a situation where we would welcome a neutral party. I had the occasion, for example, Mr. President, sit down with a group that is all about just saving democracy. Fascinating couple of hours to sit down with those individuals. And it was a nonprofit organization. And I just got to wondering if a situation would ever come up where a neutral party like that would like to help us to keep election locations open, or to help our state government to conduct the election process because we don't have as many numbers as we used to have. I guess maybe a little bit more conversation about that. I don't have heartburn about it. I just wonder if we are setting ourselves up for really closing the door for opportunities at public-private partnerships, Mr. President. Thank you.
Thank you, Senator. Let's collect a few more questions or discussion. Are we ready to go back to which one? Senator Beitman will take those.
I'll take a stab, Mr. President. Thank you. I'll take a stab at that last question. And I would offer this. I would say that most, if not all, nonprofits have an agenda, and everybody has an agenda, especially when it comes to elections. And that's what the whole purpose of this bill is to make sure that those people with agendas stay out of our sacred election processes, and they can't buy influence in how we handle and conduct our elections. And going back to the Citizens United question, I would say that was pretty well handled by the good tall senator, and that was a political speech issue, and this has nothing to do with speech. This has everything to do with how the elections are conducted on the inside. So thank you, Mr. President.
Thank you. Let's go to Senator Steinmetz. Would you like to follow up with Senator Beitman and then we'll go? Okay, deferred to you, Senator Perkins.
Thank you, Mr. President. And so I guess maybe I wasn't quite clear. I think it's a little bit too elementary to simply say, well, Citizens United was a free speech. What you had was a fundamental right. Free speech is a fundamental right. So is the ability to vote. It's the franchise that we have as voters is a fundamental right. And so as I look at this, and I understand, and I agree that money should not be accepted if the condition on which the money is provided is that you change your election laws. But the other side of it is, in my community just recently, they have reined in, and there's not as many polling places there as there used to be. Not enough money, budget cuts. So they reined in the number of polling places. If somebody came out and put more polling places, I don't know why it seems to me that that's a ban on accepting that, and it actually reduces and infringes or puts some restrictions on the ability to provide that franchise broadly. Same thing on if you were going to have poll watchers or extended hours of polls, or may ensure that there were poll watchers present. It's not always negative. There could be very positive instances where donations or other people whose agenda may simply to promote the electoral franchise, to have free and fair and open elections. And so this is one of those things that cuts both ways, where it may certainly restrict the ability of someone to buy influence, but it also may restrict the ability of people to actually make sure that that franchise, that primary franchise that we have, the right to vote, it can be overly restricted or can be restricted maybe further than it should be, or at least arguably, simply by the lack of funds, the lack of financing to provide sufficient polling or sufficient information about polling. And so I understand, again, I think it's too easy to say it's just a fundamental right regarding free speech, because it has to do with the fundamental franchise of the right to vote. Thank you, Mr. Chairman.
Okay, thank you. Senator Steinmetz, you want to follow up and answer that? And maybe you follow up to Senator Beitman as well. Oh, I hit the wrong one. There we go.
That's all right. Thank you, Mr. President. I think we're getting off track on what this bill is designed to do and the fundamental role of government. This is one of our roles and duties, to fund elections. That's our job. We shouldn't be seeking private funds to do that. And so that's what this bill seeks to do, is just keep things within the scope of government, keep it neutral and fair. It was brought to us by our chief election officer, who feels that in order to protect our elections, we need to have this in place. If there was further wordsmithing that needed to be done, I certainly would have been open to hearing. I think the last amendment was a very good one. If the House has some work to do on the other side, then that would be up to their purview. But I think this is a very important piece of legislation. It's very needed, seeing the problems that have happened in other states. And yes, with budgets tightening, we want to make sure that our elections are free from interference, free from those types of things that would skew our election and not make it the gold standard anymore. This is a bill designed to protect our elections and the process, and make sure that it's not being tampered with or moved in any direction by some outside force. So that's what the bill does. That's what it's here for. And I hope you would vote aye on this important piece of legislation.
Well, Mr. Chair, or Mr. President, that actually is interesting news to me, that our Secretary of State's office brought this bill forward. That was not my experience over the last 2 years, and we worked very closely with the Secretary of State's office. I had no idea that this came out of that office to us, but I would just go back to it, again, to the concern that I expressed before, Mr. President. You, for example, are in the information business, and if somebody wanted to step forward and provide the money so that our Secretary of State's office could mail something out to every single voter in the state to explain exactly what the voting process is and who's on the ballot and where you go to vote, sponsorship might be something that we would like. That's the public-private partnership piece that I'm concerned that we're just throwing away here. A sponsorship can be something that could be directed by that Secretary of State's office, Mr. President. It doesn't have to be nefarious or something slanted or something out of left field. It's honestly the opportunity to pay for some of the printing that we've had to cut budgets under. So that's the unintended consequences. I get that maybe we've had some struggles in other states, and we're bringing this to Wyoming to get a look at it, but that's the heartburn. Mr. President, just wanted to throw that out there. What's wrong with a sponsorship of some information that might do my constituents some good? Thank you, Mr. President.
Thank you, Senator Rothfuss, and then back to Senator Steinmetz. Go ahead, Senator Rothfuss.
Thank you, President. For my first time on for the bill, I don't have the concerns, and I didn't see the things that went bump in the night. I don't believe that anything transpired that this bill needs to protect us from in the last election. I didn't see any evidence of any of that. I just think this is good policy. I don't see it as being contrary to Citizens United in my interpretation of Citizens United. And I say that as all the legal scholar or chemical engineer canon should be. But Citizens United was specifically contemplating speech and speech on behalf of the individual and representing themselves in the speech. There is a different layer of engagement when it's a contribution from an individual to the government, and then the government distributes information on behalf of the government. And while we would all like to believe that that information that would be distributed would always be neutral, I think it's hard for us to assume that it always will. I wish it would. If I knew it would, then yeah, I'd be against this bill too, because hey, it would be handy if people just gave money to the government, we got things done. But the reality is, if there's an organization that wants to provide educational information or other information to all of the public and to distribute that, under the current system, they put their name on it, and they have to, and that's good. So you know the source of the information and where the funds came from. And we don't even do that as well as we probably should, but hey, we're trying. This would allow a circumstance where I can work around that, and hopefully wouldn't, and hopefully nobody in the government would allow it to happen. But the opportunity presents itself where I can make a large contribution, funnel it through maybe somebody that's in my party so that they can provide information that might make the points that I want them to make a little bit better than perhaps the other points, and it would look good because it would still be education. But that's not a business I think we need to get into. As a previous speaker said, Mr. President, this is the business of the state. We are supposed to hold free and fair elections. We need to find the funding to do that and to do it right. And if we find ourselves in a circumstance where we don't have enough money and we need to hold a bake sale, then maybe we need to look back here and figure out how to provide enough resources that we can get it done correctly. Because we will not have free and fair elections if we cannot contribute and provide adequate resources to do so. But we need to keep them separate and above board and ensure the sanctity of those elections, Mr. President. I think this bill moves us in that direction. And I think it's a good step, even if, once again, I don't see that we've had these problems, but this is a good, clean bill that makes sure that we don't have this naughtiness in the future, Mr. President. Thank you.
Thank you. Senator McEwen.
On and for the bill. Just want to point one thing out. We're talking about First Amendment violations. This bill does not stop a private company or entity from printing out educational material and mailing it out. I think we're getting caught up on things we don't need to be. If I want to support something, I can go to Sir Speedy, buy some flyers, and
Just no names.
walk over to the mailbox and send them out. Thank you, Mr. President.
Thank you. Just a reminder on the names, but that's okay. Thank you for your comments, Senator. We have further comments? Question on the bill? Senate File 142, Prohibition on Private Funds for Conducting Elections. Having been read 3 separate times, the question is, shall the bill pass? The chief clerk will call the roll.
Roll call on Senate File 142. Anderson. Aye. Baldwin. Aye. Beitman. Aye. Boner.
Aye.
Aye. Bouchard. Aye. Case. Aye. Cooper. Aye. Driscoll. Aye. Ellis. Aye. French. Aye. Furphy. Aye. Guru. Aye. Hicks. Aye. Hutchings. Aye. James. Aye. Kinsky. Aye. Cole. Aye. Cost. Aye. Landon. Aye. McEwen. Aye. Nethercott. Aye. Pappas. Aye. Perkins. Aye. Rothbus. Aye. Salazar. Aye. Schuler. Aye. Scott. Aye. Steinmetz. Aye. Wasserberger.
Aye.
Aye. President Dockstader. Aye. Closing vote. Closing Vote closed. Senate File 142, 30 aye.
Senate File 142, prohibition on private funds for conducting elections. Having received the affirmative vote of the majority of the members elected to the Senate, Senate File 142 has passed the Senate. Consideration of bills on general file. Mr. Majority Floor Leader, we are at that order of business, consideration of bills on general file. Oh, sorry, let's just, before we do that, Senator McEwen, privilege.
I have the privilege of the floor, sir.
Granted, sir.
Mr. President. We have some representatives from the John Patriot Group from Gillette here with us today. Ed and Susan Sisti and Mark and Patty Junick. Please stand up.
Let's welcome them to the Senate. Welcome to the Senate. Thank you, Senator. Now to you, Mr. Floor Leader.
Mr. President, I move the Senate resolve itself into committee of the whole.
You've heard the motion. All those in favor say aye. Those opposed, nay. Mr. Floor Leader, we are missing your appointed person. There he is. Very good. Senator Pappas, you are now in charge of the Senate.
Committee of the whole, please come to order. All right. The first bill for consideration is Senate File 81. This bill, yeah, we hadn't read that in, right? This is not a continuation, is that correct? Okay, yeah. Could I have the bill read in, please?
Senate File 81, Second Amendment Preservation Act, an act relating to firearms, sponsored by Senator Bouchard. Was referred to committee number 1, which returned to committee recommendation that it do pass. Ayes, Senators Cooper, French, Kolb, Cost, and Nethercott. Senator Nethercott, Chairman.
Senator Nethercott, what is your pleasure?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the due pass recommendation of Senate File 81. Senator Bouchard will explain the bill.
Senator Bouchard.
Thank you, Mr. Chairman. I want to present to you Senate File 81, Second Amendment Preservation Act. I have a tracked in copy that I sent everyone by email. And I also have some copies on at the desk up here. So there's an amendment going to come on this bill. So I would like you to get those if you can. I'm going to walk through the bill. I'm going to kind of omit some of the things that aren't going to be in the bill, if we can do that. On the first page, I'm going to actually be making a change there. I have it on the tracked in version. It's pretty self-explanatory. As we go through the bill on page 2, this is where we start out with legislative intent. And the reason that's in the bill is because if it goes to court, the courts have to see what the intention of this bill is. And I know there is people wrestle with either having legislative intent or not having it. When we see what federal actions are coming down the pike, I mean, it's very important that the courts in the state understand what we were doing with this bill. As you go to the top of page 2, it says the legislature is firmly resolved to support and defend the Constitution of the United States against every aggression. I think we all take an oath to that, so I think that's a good part in the bill here. Like I said, it's a legislative intent part of the bill. It doesn't make any solid law. As we go to the next section, it's defending rights through the Constitution. So online, it actually is acting through the Constitution of the United States. The people of several states created the federal government to be their agent in the exercise of a few defined powers.
Obviously, what we're doing in this bill is we're recognizing that, but we're also recognizing there's limitations as you go down to the next section, Romanet 3. The limitation of the federal government's power is affirmed under the 10th Amendment. And so that's basically more language to affirm what we're with legislative intent here. Go to page 3, and I'm looking at the tracked-in version. So please bear with me here because we're going to have different page numbers on the copy of the bill that's available. We go to the next page, proper role of the federal government. If the federal government assumes powers that the people did not grant it in the Constitution. What we're saying there is we don't like it. And the reason we're saying that is some of the threats that are coming out of the federal government right now are to go way beyond the power and the scope of what they should be doing on the Second Amendment. And so we are saying that there. Again, legislative intent, it's in the bill. As we go to the next section, several states of the United States respect the proper role of the federal government, but reject the proposition that such respect requires unlimited submission. Again, legislative intent, as we go down to the bottom of that paragraph, such supremacy does not extend to various federal statutes. So remember, we do have things in the 10th Amendment that do set some things apart. It has been the push from the federal government to go after gun rights full bore using the Commerce Act, everything they can. And I want to remind everybody as I'm speaking on this bill, we're date stamping this. It's going to be April 1st or forward. We'll get to that when we get to that section of the bill. As we read on the next page, there's just more, and I want to call it boilerplate language that says, this is kind of what the Constitution says.
Excuse me, Senator Bouchard. It's come to my attention that, first of all, the copy that you're reading from, that you've asked everybody to look at, which has things tracked in, there's 3 different amendments from different folks. None of the amendments have been read in, so we probably ought to be not looking at those things. So at least for now, I think we need to just stay on the bill because
Mr. Chairman, I haven't even got to any of that stuff.
Okay. Well, the chief clerk has just indicated to me that we need to be really looking at the corrected version of the bill and not a bill that's had anything tracked into it. Okay, continue.
Mr. Chairman, I wonder if we can, there is one amendment that we could just dispose of. And I think it's just a basic correction. So if we could do that now, could we do that? I believe it's.
There are 3 amendments. We have to take them in order.
Yeah, I get it.
Okay, so you're looking at the standing committee, I mean, the committee of the whole amendment number 1, is that the one?
Yes, Mr. Chairman.
Okay, could I have that one read in?
Senate File 81, Committee of the Whole Amendment Number 1, page 2, line 3.
Okay, that amendment is from Senator Hutchings. You have the floor.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment Number 1 to Senate File 81 and ask for your favorable consideration. These changes are just grammatical. You'll see uppercase used for the Constitution, and there was a couple of portions of the bill where quotes from the Constitution were not complete or accurate. So the LSO staff did make those changes, and any changes to page numbers, they will be tracking when the bill goes to second reading. Thank you, Mr. Chairman.
Do I see any other discussion? Okay, Senator Bouchard. Excuse me.
Thank you, Mr. Chairman. It's a friendly amendment.
Okay. Sensing there's no other discussion, All those in favor of Senator Hutchings' motion to adopt the Committee of the Whole Amendment number 1, Senate File 81, please say aye. Aye. Opposed, say no. Amendment, Committee of the Whole Amendment number 1 is adopted. We're back on the bill. Senator Bouchard.
Thank you, Mr. Chairman. Could I ask that the next amendment be read in?
Could we have the next amendment read in, please?
Senate File 81, Committee of the Whole Amendment number 2, page 1, line 4.
Senator Bouchard.
Could I ask, Mr. Chairman, that amendment be withdrawn without objection?
Yeah, without objection, Committee of the Whole Amendment number 2 has been withdrawn. We're back on the bill. Senator Bouchard.
And Mr. Chairman, I'd like to read the third amendment in, please.
Do we have the third amendment read, please?
Senate File 81, Committee of the Whole Amendment number 3, page 1, line 4.
Senator Bouchard.
Yeah, I'd like to move Committee of the Whole Amendment 3 to Senate File 81. And I would like to finish discussing that amendment and the bill.
Please.
So I'm still on the tracked-in version. And I will tell you, this amendment is 3 pages, so that's why I wanted to give you guys a tracked-in version. So as we're on the page 4 of the tracked-in version, we're talking more about constitutional concepts to limit the government from overreach. As we go on to page 5 of the tracked-in version, it's more overreaching federal government concepts here, power to tax. If you go down to on page 5, line 2, we've granted Congress the power to lay and collect taxes. But the concept here is that we've also used taxes to have a chilling effect on rights. And that is a concept that goes back to the 50s. It's called the chilling effect doctrine. So we just start talking a little bit about this. The legislature rejects any claim that the taxing and spending powers of Congress may be used to diminish in any way the right of the people to keep and bear arms. And this is basically affirmation against taxation and regulate. And it's, again, this is part of the bill that has the concepts of the bill for legislative intent. As we go to the next page, the Wyoming legislature strongly promotes responsible gun ownership, including parental supervision of minors, and the proper use, storage, and ownership of all firearms, the prompt reporting of stolen firearms, and the proper enforcement of all state gun laws. The Wyoming legislature hereby condemns any unlawful transfer of firearms and the use of firearms in any criminal and unlawful activity. So we're just backing up here that we did have some concepts there, but we're not trying to be unlawful here. As we continue down, we've strike out on 68409. That was the section that had the immunity clause that was pretty controversial. And so that is the first evidence that we're striking that out. As we go down on this next section of the bill, 68407, invalidation of certain federal gun laws. So this is where the concept of this bill really starts happening here, is we have a lot of threats in the federal government that are coming through Congress. And I think everybody could agree that they're there to have a chilling effect on gun owners, to have a chilling effect on manufacturers. What we're doing here on page 6 of the tracked-in version is the following federal acts, laws, executive orders, administrative orders, court orders, rules, and regulations enacted on and after April 1, 2021 shall be considered infringements on the people's right to keep and bear arms. So that's a pretty simple concept there. There's a lot of things that happen under federal law. Some things have happened recently under rules. And that's even more scary because we had a long period of time where no rules were made as drastic of what we've seen in the last 2 years. And it was a misstep. It was a misstep. The previous administration, two administrations ago, actually knew they couldn't make those rule changes. At least that's what they said. We saw something happen recently that was on a bump stock. Man, they can actually go into rules now. They've set precedent to do that, and that's why this is important. The next page, we start talking about the chilling effect. Any tax, levy, fee, or stamp imposed on firearms, firearm accessories, or ammunition not common to all other goods. So basically, any other tax that would be new that might be reasonably expected to create a chilling effect on the purchase or ownership of those items. So that's kind of what the concept is that we're talking about. It's the chilling effect doctrine from the 50s, and several cases where the chilling effect was used against the constitutional right. So that's what the concept here is. Next section, any registering or tracking of firearms, and the same language to create a chilling effect. Next section, any registering or tracking of the owners of firearms. So that's directly relating to the person. Again, laws that would create the chilling effect. Next section, any act forbidding the possession or ownership or use or transfer of a firearm, firearm accessory, or ammunition by law-abiding citizens. Again, conceptual that law-abiding citizens should not have harm from the overreach of the federal government. Next one is any act ordering the confiscation of firearms. I mean, all of these concepts are in drafted legislation in Congress. And that's the reason for the bill. On the next page, basically everything the feds can throw at us. All acts, laws, executive orders, administrative orders, court orders, rules, and regulations enacted on and after April 1st, 2021 that infringe on the people's right to keep and bear arms as guaranteed by the Second Amendment of the Constitution of the United States and Article 1, Section 24 of the Wyoming Constitution. As we go to the next section, again, this is intent. It shall be the duty of the courts and the law enforcement agencies of this state to protect the rights of the law-abiding citizens and to keep and bear arms within the borders of this state, and to protect these rights from the infringements defined under subsection A of this section. Pointing to the real law when we get there. Next section, for the purpose of this section, law-abiding citizens means an individual who does not otherwise preclude under state law from possessing a firearm and shall not be construed to include anyone who is not legally present in the United States or the state of Wyoming. So I want to just talk about that section a minute. When you possess a firearm in Wyoming, you're doing it based on federal law. And again, we've got the date stamp, April 1st. And we also have this section here that's pointing to the state. The state actually says, or actually points to the federal code. And that's how everybody in Wyoming possesses a gun, based on that code. Obviously, they could make changes. That's why we've got the April 1st timestamp. As we go on to the next page, we've started making significant changes with this amendment. So 68408, prohibition on enforcement of invalidated federal laws. So the biggest change is in the on the tracked-in version, page 9, line 6. No person, including any public officer or employee of this state, or any political subdivision or law enforcement agency of the state that employs an official, agent, employee, or department of the government of the United States acting under the color of federal law within the borders of the state. Any political subdivision of the state shall have the authority to enforce or attempt to enforce or give material aid and support or support to another who enforces or attempts to enforce. It has the same language that we've read in the intent of the bill. any federal acts, laws, executive orders, administrative orders, court orders, rules, regulations, statutes, or ordinances enacted on and after April 1, 2021. And then it basically says that what the infringing on the right to keep and bear arms as enumerated in Wyoming statute 28407A, which is a statute that we're creating in this bill. So let's go back just a little bit here to the concept here. Nullification is a tough deal, and that's not exactly what this bill is doing. What it is doing is we're not going to enforce it in the state. This doesn't really say that the feds can't come in. It says that our officers aren't going to help them. And they just don't have the resources to do that anyway. So if they pass a confiscation law, like a Clinton gun ban, they would have to rely on officers to enforce that. What this bill, like it said, enacted on and after April 1st, which is probably the closest chance we'll get if we do see something. But if they do pass something and get it rammed through, this is going to say that an officer in the state can enforce it. As it goes on page 9, line 19, any public officer, employee of the state, or any political subdivision of the state, or any political subdivision or law enforcement agency of the state that employs an official, agent, employee, or deputy of the government of the United States acting under the color of federal law while within the borders of the state, which acts knowingly. Now there's a good word there, because this bill doesn't want to go after someone who doesn't do so unless it's knowingly. And that's a pretty high standard. I think it's good to note that on the bill. Page 10 on line 2 of the tracked in version. Knowingly to violate the provisions of subsection A of this section, or otherwise knowingly deprive a resident of Wyoming of the rights or privileges ensured by the Second Amendment of the Constitution of the United States, or Article 1, Section 24 of the Wyoming Constitution. So again, we've got knowingly twice in this bill. This isn't about pinning someone who didn't know. As we go on down in that section, it says they shall be liable. So while acting under the color of any state or federal law, shall be liable to the injured party in the action at law, suit in equity or declaratory judgment, or any other proceeding for redress in such actions. So here's where we get to the meat and potatoes of the bill. On page 10, line 12, any person who is aggrieved by the violation of this section shall have standing to pursue an action in district court of the county in which the action allegedly occurred. The court may award the prevailing party, other than the state of Wyoming or any political subdivision of the state, page 10, line 19, not less than $50,000 per violation. Next section is they also receive reasonable attorney fees and costs if they win. On to the next page. If a court imposes a civil penalty as provided in subparagraph Romanet 2A of this section, attorney's fees and costs provided in subparagraph 2B of this subsection, or both the penalties and fees and costs, then the state political subdivision or law enforcement agency that employs the person who violated 68407A or subsection A of this section shall be required to pay any penalty, fee, and costs that the court orders. So this is not directed at the officer, it's directed at the agency. And yes, there's going to be some that don't like it, but there has to be teeth in the bill. There's also some safeguards here. There was things that the officers talked about in committee. Nothing in this section shall limit the authority or discretion of a public officer, or an employee of the state, or any political subdivision of the state to investigate, charge, or prosecute any person for felonies that do not constitute the infringement described under WS 68407A and subsection A of this section. As used in this subsection, investigate may include securing a weapon in the course of law enforcement safeguarding an area when performing their duties. Next section, nothing in this section shall create for a person charged with a crime a defense against being charged or prosecuted for felony criminal activity that does not constitute infringement described under WS 68407A or subsection A of this section, continued on the next page of the tracked-in version, provided that the alleged criminal activity was not initially discovered incident to a violation of subsection A or section of this section or WS 68407A. So basically, we want the police to have the ability to do their job, and those are the protections to do so. Now, we did mention felonies there, and the reason there, the threshold there is someone shouldn't be jaywalking and necessarily have more power to breach a Fourth Amendment violation. So that's why we worded it that way. Again, protection for the police to do their job. As we go on in this bill, 68409 is completely scratched from this bill. Starting on page 12 of the tracked-in version, you'll see page 13 is stricken. You'll also see page 14 is stricken. You'll see more of the immunity language. And then you get to the last page of the bill and there's just a severability clause, which basically means that if something's found not to be kosher in this bill, it doesn't reduce or diminish the rest of the bill to keep it intact for protections for the citizens. You also see that the section 4, we've changed the effective date to immediately upon completion of all acts necessary for a bill to become law. And the reason that is done is because of the April 1st date. So I think I've went through everything on the tracked-in version with the amendment, and I would like to move that amendment and ask that you ask for a favorable vote on that amendment.
Okay, we are on amendment number 3. Any discussion? Senator Perkins.
Thank you, Mr. President. I do have a number of questions. And first of all, when is the, it's been changed from a crime to a civil penalty. And my first question is the, when a law is declared to be invalidated, which has been invalidated, who determines the invalidation? Because that is it seems to me that the invalidation is required in order for the knowing provision to be violated. So the whatever law, tax, or other regulation is invalidated, how do we determine whether that, or how is the police officer or other public official who's trying to enforce a law that's been invalidated, how do they know it's been invalidated? Who does that? That's question 1. Question 2 is I'm trying to, as we do that and they get the judgment, who pays the judgment? If the sovereign immunity was waived before, has now been removed, who pays the judgment? Who pays the minimum $50,000 judgment? The other question I have is, I was looking at a case called United States of America versus Cox and United States of America versus Kettler. So this is a 2018 case United States Court of Appeals for the 10th Circuit, and Wyoming is also in the 10th Circuit. And so a case that would come out of Wyoming that would be anywhere similar to this would also be heard by the 10th Circuit, which is headquartered in Denver. And in this particular case, there were Kansas had passed bills a little bit. It's different, but it was also called the Second Amendment Protection Act. And so there was some guys that in particular manufactured silencers, and another one owned a sawed-off rifle, and they had silencers. And so they believed that under the Kansas Second Amendment Protection Act, which prohibited taxation or regulation, other things of firearms that were within the state, and also and didn't require them not to be registered and exempted them from taxes and things like that. They did that. These two individuals, so anyway, a guy who bought a silencer and a guy who sold a silencer that was made and manufactured only within the state, had never crossed lines, and they were criminally charged. And the big issue seemed to be under what's called the National Firearms Act, which is an act that taxes most of us, that requires that people transfer sell firearms and silencer things like that, be dealers and register, and they have to pay a tax. They have to pay, I think it's $1,000 and $200 for transfers, and $1,000 a year to maintain their dealership and some things like that. And so these two guys in Kansas did that. They didn't believe that the National Firearms Act applied to them. And so they didn't pay those fees, and ultimately they were charged with felonies for not following the National Firearms Act. And so they appealed this, and they were both convicted of felonies under the violations of the National Firearms Act. And so it went to trial, and they were convicted at trial. It went to the 10th Circuit, and they looked at that, and they looked at a couple things. First of all, they looked at the ability of Congress to tax. And so as recently as 6 years ago in Sebelius case, the United States Supreme Court has looked at the ability to tax. And as long as it raises some revenue, it's deemed to be it's an issue of tax. And the fact that tax regulates, if it raises some revenue, that a tax then does regulate by its very nature. There's almost no tax that doesn't regulate some behavior, or at least affect some behavior. If you pay, whether it's buying cigarettes, whether it's even in First Amendment rights in speech, you have the right to charge a tax or fee for the administration of taxes, administering security or administering the act that's being taken on. That's why sometimes even parade permits or demonstration permits require some permitting and some things like that. So even if they're fundamental rights, sometimes, that doesn't necessarily preclude a tax. And so these guys relied on it. That went up, and long story short, their convictions were upheld. And they both now have felony convictions, which ironically will prevent them from possessing firearms. But the court goes back and looks at, particularly they go back and look at, it was the tax and infringement upon the Second Amendment right. And they went back and they did a couple of things as they looked at the two-pronged test to determine if something violates or something is truly a Second Amendment right. And two things happen when you're at least under the United States Supreme Court in Heller, which is kind of the seminal case. Heller was a case where the United States Supreme Court struck down a total ban by the District of Columbia on handguns, even having them in their home. And so they set up a two-pronged case. And the long and short of it is the first thing is it an arm that's covered by the Second Amendment? Not every arm is covered by the Second Amendment. And even the Second Amendment does have some restrictions. One of the most common being that felons can't possess firearms. That's been upheld constitutionally a number of times. Also in looking at arms, as they look at arms and you go back and look at the history of the Second Amendment, it's always in the context of arms for defending yourself and your life and your property and your family. those types of arms. The ones that are commonly used to protect those things are usually protected arms, but not every arm is deemed to be necessary to do that. Another example that we have in law is submachine guns and sawed-off shotguns and short rifles. They've been looked at a couple times, and they've both held that Second Amendment doesn't apply to those particular arms because they're not common for the defense of a life or personal property, that individual right that they have. And so the court looks at that, and as they look at that, they're always looking in the context of the modern area. What is the type of gun or arm that someone must have in order to protect themselves? What is that? And that's why the handguns in Hiller why that ban was struck down, because one of the primary arms that someone uses to defend themselves, especially in their own homes, is a handgun. It's one of the main arms of choice. And so that's why that ban was stricken down, because it was an unlawful infringement on that. But not every arm is covered. Like we said, some of them have been defined by federal statute to not be protected under the Second Amendment. So my questions are, as I looked at it, this would be nice if this would all work. But the other side you have is these two poor fellows, Mr. Cox and Mr. Kettler in this case, both ended up with felony convictions that were affirmed. The certiorari to the Supreme Court of the United States has been denied. So this is the law in our circuit. And so what is it? So the two things the long and the short of that whole long explanation is one, is this law, how is this law going to protect the Wyoming citizens who rely on it? Because it sure didn't protect the two individuals in that case. And then two is that in the analysis of both the Supreme Court as recently as 6 years ago in Sebelius, the right to raise revenue is as a right that's granted Congress in the Constitution. And when you apply the supremacy clause to the right to tax, that they can tax. Now, they can't tax it out of existence, but they can tax it. And so as long as the tax is not out of hand, according to the court's analysis in Sebelius and also in this 2018 case that originated in Kansas, they can do that. And the supremacy clause says that they can cover or they can enforce that tax. And so those are the couple questions I have is how's that all going to work? Because like I said, it sure didn't work for those guys. And it had a lot of the Kansas law had a lot of the same stuff about not being able to tax and declaring these invalid and particularly on firearms that had originated and were manufactured inside the state and not transported across state lines. It had a lot of the same protections in it, but it sure didn't work for those two fellas. So help us understand how that's going to work.
Anyone else?
Mr. Chairman, are we on the amendment?
We're on the amendment. Any further discussion on the amendment? Senator Nethercott.
Thank you, Mr. Chairman. Just a couple of questions for the sponsor on the amendment. I see that we have eliminated qualified immunity, the repeal of qualified immunity in the bill, but we still have personal liability for law enforcement officers or any other public employee. So I want that to be clearly understood and explain to me the rationale for eliminating the repeal of qualified immunity, but still allowing for law enforcement officers to be sued. And kind of bolstering onto that is who pays that minimum of $50,000. I mean, that obviously would be either the officer himself or the cities or counties or state would pay a minimum of 50 grand plus. Also, if the sponsor could help me understand the difference between a civil penalty as opposed to civil damages in a civil case. I'm not familiar with that concept there. And then also just a piece here I see on page, this is the first time I'm seeing this, of course, put together this way. On page 12, page 11 and 12, that nothing in this section shall create for a person charged with a crime a defense against being charged or prosecuted for felony criminal activity that does not constitute an infringement described under the newly created 68407A, which is that recitation of potential federal gun laws, provided that the alleged criminal activity was not initially discovered incident to a violation of subsection A. So how I'm reading this, and potentially help me if I'm wrong here, let's say federal agents go into a house because they are exploring violations of the federal gun laws enacted after April 2021. They find child pornography. That guy can't be charged with child pornography because they were there for an unlawful reason to start, and they can't contact local law enforcement. Help me understand how that works out on the ground. Who makes those decisions, recognizing that there's a minimum 50K involved with that potential confusion?
Okay, we're on committee of the whole amendment number 3. Any further questions before I turn it back over to the sponsor? Senator Kinski.
Thank you, Mr. Chairman. I share the bringer's concerns about protecting our Second Amendment rights, and I think it's we're right to be vigilant. And I applaud the progress that has been made in this bill with the amendment that's proposed, and which is the subject of our discussion currently. My question for the sponsor is with respect to page 10, and on lines 2 and 3, the word knowingly is used twice. And so this comes very close to codifying existing law with respect to law enforcement. And my concern is for my law enforcement officers. I want to make sure that they're not unwittingly caught up in situations where they're not certain whether they can act or not. And so there's this doctrine of qualified immunity for police officers where they can be liable for what they do in a search or an arrest if they acted knowingly in violating somebody's constitutional rights, which and the right must be one which is clearly established statutory or constitutional rights of which a reasonable person would have known. So my question is the intent to try to put this immunity into the statute? And if so, could we make it more clear? And the reason that this doctrine of qualified immunity has grown up is the Supreme Court has recognized that when an officer is on a criminal scene or a criminal investigation, things move very quickly and they don't have time to call a lawyer and ask for a legal opinion. And so they've said, you know, a cop can be held liable if they're acting in bad faith and they violate a clearly established constitutional right of which any reasonable person would know. And if there's a question as to whether there was a constitutional violation or not, then the police nor the police department in this case, of this instance, they would have a defense. And so my question is, and I hope it's in the affirmative, is the intention to maintain that sort of good faith defense for the police department because their liability is determined by the policeman. And you can imagine what some of these scenes are like, you know, the mobile home, and there's the wife with a broken nose and broken teeth and kids screaming and a pistol on the counter that may or may not have been used in the commission of a crime, and any number of scenarios. But just, you know, officer pulls somebody over for a traffic offense and they've got a sawed-off shotgun. It just goes on and on and on. Do we intend to say that an officer has a good faith defense and that the department is only liable if the officer violates a clearly established constitutional right of which a reasonable person would know? Thank you, Mr. Chairman.
Seeing no others rising, Senator Bouchard.
Thank you, Mr. Chairman. I'm going to work my way backwards here on the questions. The word knowingly is there, but in the way this bill is drafted, it's basically immunity hasn't been touched in the statute. So the officer himself has immunity. What this bill is specifically targeted as I said before, is things that are timestamped after April 1st. All the existing laws that are on the books are there. Federal laws are there. There is no intention to go in and make it more difficult on what we have today. What we have today, the intent of this bill is to keep it the same. It's only when there's action brought by Congress on things in the future. We even have a provision here in securing the scene with weapons. I mean, that was just another little safeguard to put in. So it's in this bill. We could probably improve on that amendment if someone would so like. As this bill moves forward. So so anyway, I think the intention of knowingly is to, I don't think the intent here at all is to take anybody and a police officer and make them in some kind of trap here. This is basically for there's probably going to be some officers that don't like the way things are. I know I've spoke to some officers that are a different political persuasion. I think they would have to look at what's going on here in this bill going forward. These are protections for the people against a federal government that is overreaching. So I hope that answers the question about immunity. The concept of civil penalties and court costs. I mean, I'm not a lawyer. I think it's pretty clear what's happening here. There has to be a teeth in the bill. Somebody does something, somebody has to pay. If there's no teeth in the bill, then it's just another. It's just like the Constitution that's being ignored if there's no teeth. The concept with the child porn, the concept in this bill was that if the police come on a scene investigating a crime that has nothing to do with a law that was passed after April 1, that they could actually do everything just fine on what they're doing to prosecute or to charge or to investigate crimes. As a secondary, the concept is, as a secondary, if they've committed felonies, then they wouldn't be able to use this as a defense. That's the concept of the section of the bill, is that they can't use this language in this section as a defense for another felony that they're either have committed or in the process of committing. I mean, we saw that concept in Stand Your Ground, where the whole concept was they can't use stand your ground as a defense when they're committing a crime. So similar to that in this bill. So going back to the whole concept of, or the discussion on Class 3 weapons. That's where you get the tax stamp. They consider a suppressor a weapon, believe it or not, under 922G of the federal code. I think it's a 922G N as where suppressors are. Again, I mean, I drafted the Firearm Freedom Act back in 2010. And when that bill moved forward, we took out Class 3 weapons. So there is all the example used in Kansas is not the same as what we're talking about here. Because one, we didn't pass anything like that. We have Class 3 weapons eliminated in our current statutes from the Firearm Freedom Act. But more importantly, the date stamp is going to solidify where those codes are. They're all previous to that date. So Class 3, and by the way, there has never been a court case against Class 3. I don't believe that it uses the chilling effect doctrine as a defense. I don't know if any people know that's basically where you can own a fully automatic weapon that's manufactured prior to 1986. And there's a whole set of rules on how you can transfer those weapons. There's a $200 federal tax stamp. We're not touching any of that in this bill. So that all of that was used as an example of what happened in another state, it would have happened here if we had passed the Firearm Freedom Act in 2010. I had to think back, 2010, if we had passed that with the same language as they did in the other state, we would have already had that problem here. We didn't do that. So that's my defense of all the class 3 weapon things that we've seen in other states. We don't have it. And this bill is not targeting those things going backwards. Who's going to pay the judgment? The agency, whatever agency it is. That's what this bill is targeted as. So the penalty will be paid if found in court. Remember, this isn't a slam dunk. This isn't, hey, this is going to be, they're going to do it and it's going to happen. This is going to have to go to court. So a lot of things can happen, even when mistakes are made, of how they fix those problems. Again, the date invalidates the new gun regulation. And it is a good question. How do we get to that point? That's a good question. I don't even know what they're going to pass. All I know is a threat of what they're going to pass. At some point, the citizens want to know that we've got their backs. And if this isn't perfect, we can come back next year and we can fix it. That's what we do with all the bills we have here. So on and for the amendment. I think the amendment does a lot of the things that the scary monsters I heard in committee. And quite frankly, I'm sympathetic to the things that were said in committee. Although I did speak with rank and file officers, and what they said before we changed this bill, they said, doesn't matter to me because I'm not going to be the one taking people's guns under any new federal legislation. So, but I'm sympathetic. So we moved it to the penalty to the agency. So anyway, ask for a yes vote on the amendment.
Senator Scott.
Mr. Chairman, on the amendment, looking at 68408, Mr. Chairman, which is on page 9 of the tracked-in version, page 9, slightly different part of page 9 on page 9 of the original bill. Mr. Chairman, on the original bill, I can understand what the paragraph says. With the amendment in it, presuming it's tracked in properly, I have some difficulties. Would like an explanation. It says no person, the first line, no person including any public office, state, or any political subdivision or law enforcement agency that employs an official, agent, employee, or deputy of the government of the United States. Is this amendment envisioning that the local people are employing United States officials? That's the first question. Or is that a separate clause that is talking about deputies, federal marshals or something that aren't working for the state? Second, it says then within the borders of the state, any political subdivision of the state. What is that phrase connected to? I don't see how that fits in the sentence. Mr. Chairman, I'm concerned we have just plain an illiteracy there, and I can't tell who we're prohibiting and under what circumstances. And then there's an odd citation back and down line 15 and that's introduced by the amendment as enumerated in 24 WS. I've never seen it referred to that way. It's normally just WS thus and such. Mr. Chairman, I'm having trouble with this amendment, just understanding what it's trying to do in this paragraph, let alone the substance of it.
Senator Dockstader.
Thank you. If we're on the bill, I'd say all about Second Amendment, but we're on this amendment. And what I've heard here, I've got some concerns. I heard that we have officer immunity. The sponsor wants to clarify that, but then we shifted over to these small towns. Folks, I start to think about my small towns. If they're pulled into this, these lawsuits that are talked about, and I see the word 50,000 or whoever it could be, sure, it'll get sorted out in the courts. But how much does it cost for a little town that has to do fundraisers just to have a town park to go to court and defend something like this? Are we putting a big burden on the little towns of Wyoming all across the state? That's a legitimate question to consider as we support the Second Amendment. Thank you, Mr. Chairman.
Senator Bouchard.
Thank you, Mr. Chairman. I'll start out with how much does it cost? What does it cost a citizen to be stripped of their rights by an overreaching federal government? What is that worth? That everybody has to tighten up, figure out what's going on. I mean, we're all in the same boat. It's officers that will have weapons and will own weapons that will be unlawful if Congress has their way. So that means we're all going to have to get a little smarter and think about what's going on. The cost is there because there has to be teeth. I think that's what makes people take laws serious. I spoke to one sheriff who said to me, when I told him I was taking the immunity off, he said, I told him, well, we're going to shift it over to the agency. And he said, I didn't like that. I don't like that. And I said, well, how are we going to enforce it? How are we going to make sure that's real law? And he said, well, I hope everyone would do the right thing. And I said, well, why don't we just take all the laws off the book that you enforce, and let's hope they all do the right thing as well. And you know I was being facetious, but it's the point here. Federal government and Congress is serious. It's so bad that they've wrote actually books that are published talking about all of the language that is, and they put it through in books line by line, current books that are they're being published now. They're writing stacks of paper on how do we get rid of the Second Amendment. They know so far they haven't been able to do a repeal amendment to the Constitution, but they know they can use the chilling effect on citizens, and they know they can take rights away. We've seen it before. We've had gun bans that have been repealed because of they had a sunset date, and we got our, can you imagine that? We got our rights back because federal legislation was written with a sunset date. Now we're in threat of having those taken away by a Congress. So that's the cost. There is a cost. There's a cost to defend our rights. As I go back to the previous question, on page 9, line 17, the 24 is just it's a copy and paste. That was just a draft of, or that's when I copied it from the amendment. It was a line number, so that's not in the actual statute. On the employee or deputy of the government, that's where we have would employ a deputy, and we're paying half of his or a portion of his payroll while the feds are paying the other portion. So they would I mean, if there's a way that we could probably maybe amend that, make that clearer, that's fine. It would be friendly. But it's basically to any officer that could be possibly employed by the federal government, but for the purpose of this bill, they're being paid for by some state funds. And I think that's all the questions.
Senator Kinski.
Thank you, Mr. Chairman, and I think we could, I don't know that there's anybody in the chamber, well, that doesn't want to protect our Second Amendment gun rights, and we need to separate that from a discussion of the bill as to whether it's really going to do it in a way that is going to be workable. I appreciate the sponsor's amendment, and I'm in favor of the amendment. I'll support this amendment because I think it greatly improves this bill by striking out personal unlimited liability for officers and limiting it to a civil action. This is a tremendous improvement in the bill. It still needs some work. So one is, and I won't belabor it, but I want to make sure that we give I perhaps didn't express myself well enough. I understand that the policeman's personal liability is out, but his police department is still liable for whatever he may or may not do on a crime scene. So he's off the hook, but his department or the state still is in this civil action. So I want to make sure that we're still maintaining that idea that when you say knowingly, I think we mean knowingly in the context of existing immunity law, that they're violating a clearly established right. And that relates to what my senator from Natrona County here had asked, who actually determines whether the law is invalid or not? And is the department at risk for an officer not knowing whether a law may or may not be invalid? So the concept, and perhaps this is a Second Amendment, second reading amendment, I'd be happy to work with the sponsor on to make clear what the outer edges of the immunity. On page 11, with respect to securing the scene, that's subsection C lines 10 through 18, it's limited to felonies. And I could be wrong, but from my time on judiciary, as I recall, spousal abuse is not a felony until it's the third time. So the officer's on scene, he's securing the scene. Is he at risk for not knowing whether this is the third strike for this abuser or not? So it might be that the word felony comes out and crimes comes in, and there's some improvements I think that can be made. But on the whole, I think the amendment is a tremendous improvement on the bill, and I intend to support it. Thank you, Mr. Chairman.
Senator Nethercott.
Thank you. Thank you, Mr. Chairman. Just some clarification based on, I think, some confusing concepts that I've heard. The amendment does appear to eliminate the repeal of qualified immunity, but the amendment does not eliminate individual officer liability exposure. It simply adds another deeper pocket, the government entity. Whether or not, if an officer were to be sued under this cause of action, would be able to avail themselves of immunity protections associated with the public entity providing defense protections through defense attorneys or through the payment of the damages is unclear for whether or not that individual officer would be afforded those protections. But I want to make it clear that the individual officer can still be held liable under this bill and the amendment. We have just added, again, another deeper pocket. Good for the lawyers.
Senator Landon.
Well, thank you, Mr. Chairman. That all of this is really helpful because, like many of you, I'm wanting to get there on this bill. None of us in here, I think, want to not support the Second Amendment, but the piece right there is what I've wondered about these past several hours since we last visited, and that is, what am I taking home with this vote? What am I doing to my law enforcement neighbors? And the sponsor is not listening, but that's the piece that I really need to know. What exactly, I think the amendment makes the bill better. I agree with the senator from Sheridan County, but what are we doing to our law enforcement? Because I don't want to vote for a bill that's going to put them in jeopardy or in any way diminish their ability to take care of things. Things are deteriorating right and left for our law enforcement, and I'm just not interested in not supporting them. So if you can help me get there, that would really be helpful for me to understand the bill. Thank you.
Senator Perkins.
I just have one question. I mean, as I read the bill with the amendment, what you have is particularly if you go to page 4, line 18 on the tracked-in bill, you've now got this timestamp. But again, is the intent that any and every federal law that levies, you go through the list on 7 that is enacted on or after April 1st, is there a presumption that they infringe upon the Second Amendment? And again, it's even with the timestamp. I'm just trying to understand the effect of the timestamp on and how that applies with respect to particularly 68407, which is the basic criminal law that says that creates the violation and the standard at which these infringements are going to happen. And again, you go back to the federal, there's a number, going back to the National Firearms Act, there's registration requirements that are in the National Firearms Act. There's these taxes that are in the National Firearms Act. So that already exists before the deadline, the date stamp in the amendment. But what happens is so does any amendment to the National Firearms Act after April 1st, is that then also considered to be an infringement? That's an example of application. I'm just trying to figure out how this works. Thank you.
Senator Bouchard.
Thank you, Mr. Chairman. So, Mr. Chairman, to clear it up on the police, I'm kind of hearing that the word knowingly might do something bad to the bills. I mean, that's not what the intention was. So whatever we have to do to make sure that the personal immunity isn't there, let's fix it. I mean, I think this amendment moves it in the right direction. That's why we did it. That's why I've had several stakeholders look at it. I want the police to be comfortable with it. However, I'm going to stay true to that. Agency has to pay. There has to be a cost here to enforce the law. That's what makes everybody hold that plumb line true. To go on to the timestamp, I want everyone here to consider how we've had, other than recently, we've had a bump stock ban. If you look at the whole landscape, I mean, we went from a Clinton gun ban that basically was on the books. It got outdated because of a sunset clause, and it went away. But if we look at the activity of what's happened under gun law, it hasn't been there. You haven't heard gun owners saying, look what Congress is doing. We haven't had that till recently. Now, I mean, we've got both houses and the executive branch that they could actually get something done. We haven't had that in a while. It's serious. That timestamp is pretty important. I mean, I don't think I can stress this enough. I mean, all the things that we're talking about have happened in most of your gun control laws a long time ago. I mean, I just really can't see where look, next year we come back, if they haven't done anything, then we don't have any work to do. If they pass something and there's some loopholes, I don't think it's going to be that hard to fix. If they pass something that's a loophole fix, I don't think that's going to be a problem. There's going to be some way that a purchase is done using the FBI when they do a background check. I don't think there's gonna be a problem here. Gun owners aren't arguing about those things. They're not arguing about going down to a gun store, having to do a background check. Quite frankly, in this state, if someone has a concealed carry permit, they don't even have to have a background check when they purchase a firearm. That's not the minutia we need to be stuck in here. This timestamp is about going forward and bad things coming out of Congress and becoming federal code. That's what this is about. On and for the amendment. I think it moves us in the right direction. And I'll be glad to work on the things that we see as problems. Thank you.
Senator Wasserberger, did you have a comment?
Yes, Mr. Chairman, thank you. I just had a quick question for the sponsor. A number of years ago, I served on the Title 25 task force, and I was wondering how this would cause law enforcement to be placed at risk for if they were seizing someone who was mentally insane, if they were taking their handguns or rifles or what have you, based on the safety of not only the person who is mentally insane, but also those around him. And I was wondering how Title 25 would come into this, but it doesn't specifically say anything in the bill about that. So question for the sponsor. Thank you, Mr. Chairman.
Senator Bouchard.
Thank you, Mr. Chairman. I want to stress the purpose of this bill one more time. There's nothing in this bill that is there to stop a police officer from doing their job in the normal course of duties. What this bill is aimed at is things that are passed after April 1st. So, I mean, what I'm seeing here is there would have to be a let's just say a black rifle ban, and they were going to confiscate it without other reasons. They're doing it, in other words, to take the weapon from the person. That is what this bill is aimed at. It's not aimed at securing a scene, doing all the things that a police officer does. And quite frankly, under federal law, if someone is adjudicated mentally defective, or even if they are on the scene, there are actions in the federal code to do things. So I just don't see that being a problem. We could write another clause if that makes everyone feel better, but that's not what this bill is. This bill is not directed at even a handgun on a scene where they have to secure the scene. This is about taxation, chilling effect laws that, or even laws that are like bans. We're looking at things that are coming down the pike in the future. So I hope that answers the question.
Senator Dockstader.
Thank you. What I heard here, and if there are promises to clarify it and to correct it, what I heard here is we still put our officers at risk. They don't have immunity. I think I heard that in the discussion on the floor. I'd like to know just exactly where we're at on that. And in my question to asking how much this is going to cost our little municipalities around the state, I heard something to the expression that it's the cost of doing business. No, I want to know. In my area, I have very small towns. Their population signs are under 1,000 in some cases, and you go all the way across the state, 1,000, 2,000. They run very tight budgets. What's it going to cost? Even if it's dismissed, what will it cost that municipality to go to court? I didn't get an answer on that.
Senator Bouchard.
Thank you, Mr. Chairman. I think there are lawyers that charge anywhere between $150 and $300 an hour. I mean, it's really going to be depending on how bad it was to defend. So I can't answer that question. I will tell you this, since we're talking about this subject, in a place called Freedom, Wyoming, of all places, when there was a Marine, decorated Marine training pilot driving through on his Harley, and he was stopped and detained. And they knew he had a firearm because he was open carrying. If you watch the video, it was just purely ridiculous that the officers would detain him for that long. I mean, you got to ask yourself, what was the real deal? Of course, the cameras weren't working conveniently, but the person did have a video going himself. And when the supervising officer showed up on scene, you could see you couldn't hear him, but you could see his actions. It was like, what are you guys doing here? Let him go, cut him loose. Nobody wants to see officers penalized for that kind of stuff. But it happens. There is a cost to taking away people's liberty. That's what it all comes back to. So, Mr. Chairman, I don't even like bringing that case up, because what I will tell you next is going to give you something that maybe puts you at ease. Now there's case law that says the police can do what they want on those kind of stops. That's a fact. I would have never pushed it to the courts. But nevertheless, it went to court, and that's what's on the books now. So I think as far as the immunity, I want to touch it again. If the word knowingly somehow messes up the immunity that's already in place, then we can take that off. The intention of this bill is not to go after that immunity. It is going to go to the pockets of the agency. Again, there's a cost to taking liberty from citizens. That's what's going on here in this bill. I'll stand for any more questions. I'd ask that you.
Senator Perkins.
Thank you. Just to answer the president's question, of course, it all just depends on the facts of the case, but it's probably 15 to 25 on a dismissal and probably $50,000 to $100,000 if the case went to trial.
Senator Kinski.
Mr. Chairman, just to the sponsor, to clarify, knowingly is not messing this up. Knowingly actually brings a great deal of relief because it sets a standard. And so I didn't mean to say that knowingly is causing a problem. It actually really helps the bill, which is one of the reasons that I would like to see this amendment move forward and us continue to work on the language.
Okay, we're on Amendment 3. Are you ready for the question? Okay, all those in favor of Senator Bouchard's motion to adopt Committee of the Whole Amendment number 3 to Senate File 81, please say aye.
Aye.
Those opposed, please say no. Amendment number 3 has been adopted. We're back on the bill. Senator Hicks.
Mr. Chairman, I've got a lot of concerns with this bill, the way it's currently constitutionally constructed. And I've got some problems that I hope that the sponsor can help me work through. So when I go through here, if we flip over to page 3 and you go to line 6. So you go into subsection 4 here, it says if the federal government assumes powers that the people did not grant it and the Constitution of the United States acts are unauthoritative, void, and of no force. Well, first thing I find it's a little bit of constitutional construct here is I don't believe it was the people that granted the Constitution. I believe it was ratified by the states. That's just a technical point. The operative point is here is void and of no force. And then we see similar language when we get over to, let's go to page 6. We get down in here, it says the following acts, federal laws, executive orders. It goes into this theory again of the whole title of that section. We bring in a new law, invalidation of certain federal laws. You go over to page 8, you go to line 10, and it shall be considered null, void, and no effect to it in this state. And then you bring in the new subsection 6848, prohibition and enforcement of invalidated federal laws. So if you flip back and you go back, so there's a long history in the United States associated with what we call the Kentucky and the Virginia resolutions of 1760 or 1797 and 1798. And that was a promulgation of a series of resolutions that come out of those two states to say they could nullify anything in the Constitution or federal laws which the state decided they didn't like. That was actually went out just for potential look by the other states. 4 of them didn't even act on it. 3 of them rejected it. 2 of them supported it. The point being is this nullification thing has come to be called compact theory. So I'll take you to page 3. And if you go to Romanet number 5, we can pull some of this language very similar out of the Kentucky resolution of 1798. There's a whole history of what develops is called compact theory. Well, let me tell you a little bit about compact theory. The whole justification for this has been tested in the Supreme Court. It's been tested by other states. There is a remedy to this, and this is my concern. Nullification has been tested over and over and over again. Early on, when I first came down here to the legislature, I had bought into the idea of nullification. But through a period of time and study and education and looking at the issue, there is other remedies prescribed by the Constitution that we are afforded to when we find these federal actions that we as a state think abridge the Constitution or violate the Constitution. Nullification is a theory that has been soundly rejected over and over and over again by the states, by the courts, and by the people of the United States. You know, when we look at this, so what is the remedy? What's the remedy? Are we going to nullify federal laws? How do we do that? What's the legal basis? Could somebody please show me in the Constitution what the remedy is for when we find a federal law objectionable to the state of Wyoming? Well, the remedy's there. I just can't find the clause in the Constitution that says you can use nullification. We have a court system set up, and we had a real good debate a week ago about the remedy that Congress afforded us. It's called Article 5 of the Constitution. So if the courts don't work for you, we as a state have the ability to go almost directly to the federal or to the Supreme Court if we find another state that's in conflict or in agreement with us. There's all kinds of remedies afforded in the Constitution to deal with this. Nullification does not work, has not worked. In fact, I'd like to give you the ultimate disposition of nullification. See, we had this thing as this theory continued to build, and it's been tried over and over again. South Carolina passed nullification in 1828 and 32. There's a whole series of Supreme Courts and issues. But it culminated in this thing called Abraham Lincoln also rejected the compact theory, saying that the Constitution was binding contract amongst the states and cannot be unilaterally changed by one party. One party. Over 500,000 Americans died trying to find the final disposition of nullification. It was called the Civil War, folks. That's what it was all about. Nullification of the Constitution and the laws promulgated by the United States of America. I've got some real concerns with this. There is not a single person in here is not a staunch defender of the Second Amendment rights to the Constitution of the United States of America. There is a right way and there is a wrong way to do this. The whole theory of nullification is the wrong way. I am no different than anybody else in here. The federal government can come and get my guns when they pry my cold, dead fingers off of them. That's when they can come and get my guns. I'm going to support this bill for right now. And I'm going to do my best to work with the sponsor on this bill to bring something that we can legally defend in the state of Wyoming, that we can put teeth behind the actions of the state of Wyoming, that we can protect the rights of those citizens under the Second Amendment right. But nullification is not the tool that's going to get us there, folks. It is not. I would ask you to vote for the bill on this reading. Let's work with the sponsor and those co-sponsors. There is a remedy to this. I'm convinced it's out there, but this is not the method to do it.
Okay, Senator Hutchins. We're on the bill.
On the bill, thank you, Mr. Chairman. Just a quick comment and maybe clarification, but I do believe that nullification has been used among the states to kind of nullify federal law on marijuana use. Thank you, Mr. Chairman.
Senator Dockstader.
Just a clarification, we've been in our amendment and now on the bill, we've been dancing back and forth between amendments and bills. We are on the bill. That's the.
We are on the bill. The amendment has passed.
Asking for your clarification, Mr.
Yes,
Chairman.
the amendment has passed. We are on the bill. Senator Anderson.
Mr. Chairman, I'm a Vietnam veteran from a long line of combat military veterans. I own an arsenal of hunting rifles and pistols. I support the Second Amendment completely, but I'm confused by this bill. This bill is complicated, almost multiple subjects. And it's like a group of legal minds got together and each one of them wrote a paragraph to it. I think in protecting our Second Amendment rights, I fear this bill is a damp squib. Thank you.
Senator Bouchard.
Thank you, Mr. Chairman. I heard a really good argument against nullification. Probably one of the best ones I've ever heard. That would be great, but that's not what this bill does. This bill says that we're not going to enforce it within the state. And there's been a lot of code or cases where the feds just can't make you do it unless they're paying for it. So that's kind of what this bill does. It doesn't say the feds can't come in. Feds can come in and do it if they want. It's saying that we're not going to do it here. And quite frankly, the officers that I've spoken to, they want a tool like this. They want to say, yeah, the feds came in and said, we're going to confiscate black rifles. Well, they don't want to do that from their neighbor and their brother-in-law and their nephews and all their neighbors. This bill is not the argument of nullification. And quite frankly, there was another mention by another senator from my county. They do nullify. Are we gonna tell me that when the marijuana bill comes over, are the same people gonna stand up and say that too? And I'm just asking because it's gonna come over eventually. And I'm just going to say the other states are doing it. They're doing nullification. And it's what's amazing to me, it's not enumerated in the Constitution when they're doing it. This is about something that's enumerated in the Constitution. It's a right. We're not talking about other things. We're talking about gun rights. I think most of the people get this. I don't understand why there's a problem here. We're not nullifying. We're saying we're just not going to enforce it here. And we're saying we're not going to enforce something that happens after April 1st. Look, the Second Amendment isn't about hunting. It's not about hunting rifles. It's about rifles that you protect yourself and your family with. And I know people don't like to hear this, but it's about protecting yourself from an overbearing, overreaching government as well. That is what is in the Constitution. So I think we should move forward and protect our people. Thank you.
Senator Perkins.
Thank you, Mr. Chairman. Again, some questions about the bill, because, Mr. Chairman, it's really nice to talk about the concept of a bill and what's it intended to do. But, you know, I've defended people against the overreach of government in federal court that didn't have a single person, didn't have a single state agency assist in the apprehension or the conviction or the trial and the charging of that person. And so people have to live. People have to kind of know what it does. So it's not just, you know, it's, again, I agree with it, with what everybody said. No one, I don't know anybody in here that is trying to take away the Second Amendment rights. But I submit to you and to the body that it's not just a matter of having some nice words and a nice concept. There's actually an application on the ground that affects people's lives. In the case I read to you, two people, they thought they had it right because Kansas had done something similar. It's same name, but had some of the same concepts, but it was also a felony to aid or assist in that. They relied on that and they ended up with felony convictions in federal court. So how this works and how people understand it is essential. And so you come back to the bill is now amended, and I come back to the question I asked again. So, because how is anybody supposed to understand what it is they can and can't do under the Second Amendment right? So now the bill is amended on page 6 of the corrected thing. So the following federal acts, laws, executive orders, administrative orders, court orders, rules, and regulations enacted on or after April 1st, 2021 shall be considered infringements on the people's rights to bear arms as guaranteed by the Second Amendment of enacted on and the Constitution of the United States and Article 1, Section 24 of the Wyoming Constitution within the borders of the state, including but not limited to any tax, levy, or stamp imposed on all firearms, firearm accessories, or ammunition not common to all other goods and services that might be reasonably expected to create a chilling effect on the purchase of ownership or of those items by law-abiding citizens. I come back again to the National Firearm Act. It's already in there. It was enacted before April 1st of this year. And it imposes a tax. I think it's $5 on transfer. It's $200 on transfer of category 3 of the category 3 weapons. It's $1,000, I think, for dealers. There's a tax. And going back, the 10th Circuit's already held that that's a tax. It's a tax. It's recognized that any tax will, to some degree, chill effect, that every tax has some effect on what that does. So I come back again to just a simple question. If they, again, and also the National Firearms Registration Act requires registration of every firearm in order they can know who to tax when it's transferred. So I come back again. So if the National Firearms Act now exists, but if it's changed, the tax is changed, it's increased, anything happens there, is that an infringement on the Second Amendment right because that the National Firearms Act has been amended after that date? Is that intended to avoid the application of that law within our state as to the amended provisions of the National Firearms Act if that were to happen?
Senator Scott.
Mr. Chairman, you know, I think many of us here, myself included, feel it is important that we take steps to defend our Second Amendment, because I think it is under threat. But there seem to be problems with this bill. I would make a few suggestions. This bill sure looks like it's an attempt to nullify federal laws. And that just doesn't cut it. We can't do that. That's well settled. Look at this. If you want to leave practical analysis, look at what happened to South Carolina in 1832 when they tried and had to back off because President Jackson said he would come down and hang them high for treason, and they knew he meant it, very literally. Look at the Civil War, all the destruction that caused, and the loss of life. That theory's been rejected. And if you look at it from a legal perspective, you've got the supremacy clause in the US Constitution and the judicial Article 3 of the Constitution, the judicial clause that clearly makes the Supreme Court the judge of whether something is constitutional or not. Oh, they're the ones that can decide that. So that's a problem. The immunity for the police officers and the effect on the small towns is a problem. Frankly, I think there's some illiteracies in the bill. Just technical things that just don't work. Those could be fixed. What I'm going to suggest to you is that we need a radical simplification of this bill to get rid of the problems. Why do we need a purpose clause at all? We don't usually use them. Why don't we just take that out and take out some of the other rhetoric that's in here? Get down to the basics. I'd ask you to consider that. We need a radical simplification of what we're doing here so we don't hit our small towns and our large towns. I represent both. They can't afford it either in these days. Why don't we look at some of that? And I would also call the Senate's attention to 914-101, which is entitled Second Amendment Defense as part of our statutes. And we need to remember that that's there. And that's already there because this legislature over the years has been concerned about defending the Second Amendment. So, Mr. Chairman, I think probably better part of wisdom to pass this through committee of the whole, but we really need to fix this thing before we vote on it third reading.
Senator Bouchard.
Thank you, Mr. Chairman. So we've come back to the date, Mr. Chairman, the date stamp on this bill. And I'm kind of glad we did come back because it lets me speak about how gun laws work. So the first part of the firearm laws in statute were 1934. And that's where you started getting your gun control. There's one organization, it's actually called the, well, I guess I can't say formal names, but it would be an organization that they would speak in Hebrew. And they were ones that believed that their rights were being taken away. The founder of that organization has passed away. He was a very nice man. I worked with him on certain issues. It's amazing. They published a book that showed that the 1934 Gun Control Act was very similar to European gun control that was in the same time period. So almost like it was international law. So that's pretty interesting about 1934. The next time was 1968, and they came back and took another little dig at it. And they put some more gun control in. And that's where you started to get the regulations on Class 3 weapons. Interestingly, some of the things that happened were on sawed-off shotguns. And if you look at that law, some of that law is so odd that you can buy a really nice sporty shotgun that you can wear on your side almost, and it's legal. But then if it was a shotgun that has a butt on it that was sawed off, it's illegal, and it's a bigger rifle than the other one that you can buy. So it's really, some of these laws are really hard to understand. That's the way gun laws typically are. Heck, Congress started it. After that, it was 1985. So we've got 1934, 1968, and 1985. And that's the major construct of our gun laws until we got to, I can't remember the year of the black rifle ban, but that one has went away. So I mean, that gives you the time frame of how long it takes for things to happen. And I think right now we're looking at what could happen in Congress. What's going on now? What could happen? I mean, so we're going to jump from 1985 to whatever they do next. And our citizens need to be protected. Not just by us, but by the whole system. Interestingly, I mean, I want to come back to the radical simplification. Many of you know last year, I'm one of the people that voted against the radically simple bill. It didn't really do anything. And if we get to that point again, everybody knows I'll be voting no. We got to have something that really works. The bottom line is that everybody involved, us all the way down to law enforcement, we can't afford to let the federal government take away our rights. That's the bottom line here. On and for the bill.
Okay, are you ready? Sounds like you are. All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report, that it do so with favorable recommendation on Senate File 81, please say aye.
Aye.
Those opposed, no. Senate File 81 is passed the committee of the whole. Mr. Majority Floor Leader, do you have something for us?
Beg, rise and sit again.
You've heard the motion. All in favor say aye.
Aye.
Opposed say no. Motion has carried. I'll put it on. Clean up my spot here, Mr. President.
That was a sound. Maybe that was
No reports, announcements? Senator Pappas, do you have okay. Announcements. You've heard the motion. All those in favor say. What?
I make a motion first. Gotta make the motion. Gotta make a motion.
Thought he did.
Mr. President, I move we stand recessed till 2 p.m.
All right, now you've heard the motion. Now we're going to go to announcements. Announcement, Anderson.
Announcement, Mr. President, your favorite committee, Minerals number 9, will meet today at noon, 15 minutes after we get out of here, which is 20 till 1 or so, to hear the following bills: House Bill 64, Uniform Fraudulent Transfer Act, extinguishing claims. And House Bill 68, Wyoming Statutory Foundation Act, House Bill 104, Uniform Trust Code Amendments, and House Bill 102, Wyoming Preference Act of 1971. So if you're on any of these bills, please come and present the bill to the committee. Thank you.
Further announcements, further announcements. Senator Landon.
Thank you, Mr. President. Your Transportation Committee, just a reminder, we will meet upon adjournment this afternoon in Capitol Extension Room W2 to take up three bills. House Bill 21, Wyoming National Guard Preference for Education. House Bill 17, engrossed, range management at military training areas. And House Bill 22, engrossed, Wyoming Military Code. Thank you, Mr. President.
Senator Kinski.
Mr. President, today, 15 minutes after we break for lunch, the Senate Appropriations Committee will meet in room W113 to hear HB 87 Provider Recruitment Grant Program, HB 107 Retirement System Efficient Disbursement Method, and any referrals as assigned.
Further announcements? There being none. You've heard the motion. All those in favor say aye.